you may be seated. All right, ladies and gentlemen of the jury, good morning. All right, the defense having rested, what says the state?
State rested closes, Your Honor.
And the defense?
Rest of close, Your Honor.
All right, both sides having closed, the court has prepared the court's charge to the jury. This contains all of the law that you are to apply to the evidence in this case. I will now read it to you. You don't have to memorize it. The court's charge goes with you into the jury room for your deliberations. And then we will have arguments of counsel. The state will go, then the defense, and then the state gets to close. Court's charge to the jury. Members of the jury, the defendant, Madeline Stanford, has been charged by indictment with the felony offense of murder, alleged to have been committed on or about the 3rd day of October 2021 in Dallas County, Texas. To this charge, the defendant has entered a plea of not guilty. Offense definitions. Our law provides that a person commits the offense of murder if she intentionally or knowingly causes the death of an individual, or if she intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. Term definitions. An act means a bodily movement, whether voluntary or involuntary, and includes speech. Person means an individual. Individual means a human being who is alive. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Mental state definitions. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Murder. Application of the law to the evidence. Now, if you find from the evidence beyond a reasonable doubt that on or about the 3rd day of October 2021 in Dallas County, Texas, the defendant, Madeline Stanford, did unlawfully then and there intentionally or knowingly cause the death of Tonabari Badon, an individual hereinafter called deceased, by shooting deceased with a firearm, a deadly weapon. Or, if you find from the evidence beyond a reasonable doubt that on or about the 3rd day of October 2021 in Dallas County, Texas, the defendant, Madeline Stanford, with intent to cause serious bodily injury to Tonabari Badon, did unlawfully then and there commit an act dangerous to human life, to wit, by shooting deceased with a firearm, a deadly weapon, and did thereby cause the death of Tonabari Badon, an individual, then you will find the defendant guilty as charged in the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict, not guilty. If you find the defendant not guilty of the offense of murder as charged herein, you will next go on to consider the lesser included offense of manslaughter. Manslaughter. Mental state definition. A person acts recklessly or is reckless with respect to the result of her conduct when she is aware but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the actor's standpoint. Application of the law to the evidence. Now, bearing in mind the foregoing instructions, if you find and believe from the evidence beyond a reasonable doubt that the defendant, Madeline Stanford, on or about the 3rd day of October 2021 in Dallas County, Texas, did unlawfully then and there recklessly cause the death of Tonabari Badon, an individual, hereinafter called deceased, by shooting deceased with a firearm, a deadly weapon, then you will find the defendant guilty of the lesser included offense of manslaughter. If you should find from the evidence beyond a reasonable doubt that the defendant, Madeline Stanford, is guilty of either murder or manslaughter, but you have a reasonable doubt as to which offense she is guilty of, then you will resolve that doubt in the defendant's favor and find her guilty of the lesser included offense of manslaughter. If you have a reasonable doubt as to whether the defendant is guilty of any offense defined in this charge, then you will acquit the defendant and say by your verdict, not guilty. Statutory defenses instructions. It is a defense to prosecution that the conduct in question is justified under our law. You are to consider the statutory defense defined in this charge in determining if the defendant is guilty of any alleged offense. The statutory defenses described herein are self-defense and defense of a third person. The defendant is not required to prove self-defense or defense of a third person. It is the state's burden to prove, beyond a reasonable doubt, that self-defense or defense of a third person does not apply. If you have a reasonable doubt as to either defense, you must acquit the defendant and say by your verdict, not guilty. Self-defense defined. Under our law, a person is justified in using force against another in self-defense when and to the degree she reasonably believes the force is immediately necessary to protect herself against the other's use or attempted use of unlawful force. The use of force against another is not justified, 1, in response to verbal provocation alone, or 2, if the actor provoked the other's use or attempted use of unlawful force, unless the actor abandons the encounter or clearly communicates to the other her intent to do so, reasonably believing she cannot safely abandon the encounter, and the other nevertheless continues or attempts to use unlawful force against the actor. A person is justified in using deadly force against another if she would be justified in using force against the other in the first place, as set out above, and when she reasonably believes that such deadly force is immediately necessary to protect herself against the other person's use or attempted use of unlawful deadly force, or to prevent the other's imminent commission of aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated kidnapping, or aggravated robbery. A person is justified in using force or deadly force against another to protect a third person or persons if, under the circumstances as she reasonably believes them to be, she would be justified in using force or deadly force to protect herself against the unlawful force or unlawful deadly force she reasonably believes to be threatening the third person or persons she seeks to protect, and she reasonably believes that her intervention is immediately necessary to protect the third person or persons. The term reasonable belief, as used herein, means a belief that would be held by an ordinary and prudent person in the same circumstances as the defendant. The term deadly force, as used herein, means force that is intended or known by the person using it to cause, or in the manner of its use or intended use, is capable of causing death or serious bodily injury. A person who, 1, has a right to be present at the location where the deadly force is used, 2, who has not provoked the person against whom the deadly force is used, and 3, who is not engaged in criminal activity at the time deadly force is used, is not required to retreat before using deadly force to defend herself. If you find from the evidence that the defendant was such a person, or if you have a reasonable doubt thereof, you may not consider whether the defendant failed to retreat in determining whether the defendant reasonably believed that the use of deadly force was necessary. You should consider all of the facts and circumstances in evidence before you, all relevant facts and circumstances surrounding the use of force or deadly force, if any, the previous relationship existing between the defendant and the alleged injured party, together with all relevant facts and circumstances going to show the condition of the mind of the defendant at the time of the alleged offense, including any and all threats previously communicated to the defendant from the alleged injured party. In considering such circumstances, you should place yourselves in the defendant's position at the time and view them from her standpoint alone. Application of the law of self-defense or defense of a third person to the evidence. Now, if you find and believe from the evidence beyond a reasonable doubt that on or about the 3rd day of October 2021 in Dallas County, Texas, the defendant, Madeline Stanford, did unlawfully, then and there, intentionally or knowingly cause the death of Tonobari Badon, an individual, hereinafter called deceased, by shooting deceased with a firearm or deadly weapon, or if you find and believe from the evidence beyond a reasonable doubt that on or about the 3rd day of October 2021 in Dallas County, Texas, the defendant, Madeline Stanford, with intent to cause serious bodily injury to Tonobari Badon, did unlawfully, then and there, commit an act clearly dangerous to human life, to wit, by shooting deceased with a firearm or deadly weapon, and did thereby cause the death of Tonobari Badon, an individual. Or, if you find from the evidence beyond a reasonable doubt that the defendant, Madeline Stanford, on or about the 3rd day of October 2021 in Dallas County, Texas, did unlawfully, then and there, recklessly cause the death of Tonobari Badon, an individual, hereinafter called deceased, by shooting deceased with a firearm or deadly weapon, you will then consider whether the defendant's conduct was justified as self-defense or defense of a third person. Self-defense. When a person is attacked with unlawful deadly force, or she reasonably believes she is under attack or attempted attack with unlawful deadly force by someone, and there is created in the mind of such person a reasonable expectation of fear of death or serious bodily injury to herself at the hands of such an assailant or assailants, then the law excuses or justifies such person in resorting to deadly force by any means at her command, to the degree she reasonably believes immediately necessary, viewed from her standpoint at the time, to protect herself from such attack or attempted attack. In determining the existence of real or apparent danger, it is not necessary that there be an actual attack or attempted attack, as a person has a right to defend her life from apparent danger as fully and to the same extent as she would had the danger been real, provided that she acted upon a reasonable apprehension of danger as it appeared to her from her standpoint at the time, and that she reasonably believed such deadly force was immediately necessary to protect herself against the attacker or attackers' use or attempted use of unlawful deadly force. Now, bearing in mind the foregoing definitions and instructions, if you believe from the evidence beyond a reasonable doubt that, at the time of the alleged offense, the defendant is guilty of murder or the lesser offense of manslaughter as defined in this charge, but you further find from the evidence, or have a reasonable doubt thereof, that the defendant reasonably believed that she was under attack, attempted attack, or apparent attack with unlawful deadly force from Tonobari Badon, and that the defendant reasonably believed, as viewed from her standpoint, that such deadly force as she used was immediately necessary to protect herself against such attack, attempted attack, or apparent attack, and so believing she shot the deceased with a firearm or deadly weapon, then you shall acquit the defendant and say by your verdict, not guilty. If you do not so find, and you do do not have a reasonable doubt thereof, you will reject the justification of self-defense and consider the defense of deadly force in defense of a third person. Defense of a third person. A person is justified in using force or deadly force against another to protect a third person if, under the circumstances as she reasonably believes them to be, she would be justified in using force or deadly force to protect herself against the unlawful force or unlawful deadly force she reasonably believes to be threatening the third person or persons she seeks to protect, and she reasonably believes that her intervention is immediately necessary to protect the third person or persons. Now, bearing in mind the foregoing definitions and instructions, if you believe from the evidence beyond a reasonable doubt that, at the time of the alleged offense, the defendant is guilty of murder or the lesser offense of manslaughter as defined in this charge, but you further find from the evidence or have a reasonable doubt thereof that the defendant reasonably believed the deadly force she used was immediately necessary to protect her daughter Eliana or her unborn baby, or both of them, against such attempted attack or apparent attack from Tonabari Badon, and that the defendant reasonably believed, as viewed from her standpoint, that such deadly force as she used was immediately necessary to protect her daughter Eliana or her unborn baby, or both of them, against such attack, attempted attack, or apparent attack, and so believing she shot the defendant with the deceased, with a firearm, a deadly weapon, then you shall acquit the defendant and say by your verdict, not guilty. Indictment instructions. An indictment is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence of guilt, nor can it be considered by you in passing upon the question of guilt of the defendant. The fact that a person has been arrested, confined, indicted for, or otherwise charged with an offense does not give rise to any inference of guilt in the trial. Presumption of innocence instruction. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The law does not require that a defendant prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after a careful and impartial consideration of all the evidence in the case. Instruction regarding bias. You are instructed that jurors must be able and willing to make careful and impartial decisions that are not based on bias or prejudice. Do not let any personal bias, prejudice, sympathy, or resentment on your part, or any such personal emotion on your part, enter your deliberations or affect your verdict in this case. All persons deserve fair treatment and equal justice under the law, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You must set aside your own personal biases and prejudices during your deliberations and base your verdict on the evidence. Decisions based, either wholly or in part, on unfair stereotypes have no place in a criminal trial and will taint any verdict which is not based solely on the evidence and these instructions. Extraneous offenses. You are instructed that if there is any evidence before you in this case regarding the defendant having committed any offense other than the offense alleged in her indictment in this case, you cannot consider said evidence for any purpose unless you find and believe from the evidence beyond a reasonable doubt that the defendant has committed such other offenses, if any. Even then, you may only consider the same in determining the state of mind of the defendant. Motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident of the defendant, if any, in connection with the offense alleged against her in the indictment. Burden of proof instruction. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. and if it fails to do so, you must acquit the defendant. The burden of proof in all criminal cases rests on the state throughout the trial and never shifts to the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit her and say by your verdict, not guilty. Evidentiary instructions. At times throughout the trial, the court has been called upon to pass on the question of whether or not certain offered evidence might be properly admitted. You are not to be concerned with the reasons for such rulings and are not to draw any inferences from them. Whether offered evidence is admissible is purely a question of law. In admitting evidence to which an objection is made, the court neither determines what weight should be given such evidence nor passes on the credibility of the witness. As to any offer of evidence that has been rejected by the court, you, of course, must not consider it. The same. As to any question to which an objection was sustained, you must not conjecture as to what the answer might have been or as to the reason for the objection. You are instructed that you are not to allow yourself to be influenced in any degree whatsoever by what you may think or surmise the opinion of the court to be. The court has no right by any word or any act to indicate any opinion respecting any matter of fact involved in this case, nor to indicate any desire respecting its outcome. The court has not intended to express any opinion upon any matter of fact in this case, and if you have observed anything which you have or may interpret as the court's opinion upon any matter of fact in this case, you must wholly disregard it. You are instructed that you may consider all relevant facts and circumstances surrounding the death, if any, and the previous relationship existing between the accused and the deceased, together with all relevant facts and circumstances going to show the condition of the mind of the accused at the time of the offense, if any. Deliberations instructions. After you retire to the jury room, you should select one of your members as your presiding juror. It is his or her duty to preside at your deliberations, vote with you, and when you have unanimously agreed upon a verdict, to certify your verdict by using the appropriate form attached hereto and signing the same as presiding juror. Your verdict must be unanimous and shall be arrived at by due deliberations and not by majority vote or any method of chance. It is only from the witness stand that the jury is permitted to receive evidence regarding the case, and no juror is permitted to communicate to any other juror anything he may have heard regarding the case from any source other than the witness stand. You are instructed that any statement of counsel made during the course of the trial or during argument not supported by the evidence, or statements of law made by counsel not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. If members of the jurors disagree about the statement of any witness, the court reporter will read back to you certain testimony. The court will allow the court reporter to do this only if you submit a written request to the court signed by the foreperson that 1. States that members of the jury have a disagreement about a specific statement of a witness, 2. Identifies the witness who made the statement, and 3. Requests the testimony be read back. The court will then have the court reporter read back only that part of the statement that the members of the jury disagree about. During your deliberations, you are also instructed that you must not communicate or provide any information to anyone by any means about this case. You may not use any electronic device such as a telephone, cell phone, smartphone, iPhone, or computer to access the internet or any internet service or any text or instant messaging services, or enter any internet chat room, post on a written or video blog, or post on any social media application such as Facebook, Snapchat, LinkedIn, YouTube, Instagram, TikTok, True Social, or X, which was Twitter, to communicate to anyone any information about this case or conduct any research about this case until the court accepts your verdict, if any. After you have retired to consider your verdict, no one has any authority to communicate with you except the bailiff who has you in charge. You may communicate with this court in writing, signed by your presiding juror, through the bailiff who has you in charge. Do not attempt to talk to the bailiff, the attorneys, or the court concerning any question you have. Your sole duty at this time is to determine the guilt or innocence of the defendant under the indictment in this cause, and restrict your deliberations solely to the issue of guilt or innocence of the defendant. If you have a verdict, or if you wish to have a break, turn on the red light and the bailiff will quickly respond. Signed by me, Judge Nancy Mulder. The very last page has your verdict forms. There are 3. We, the jury, unanimously find the defendant, Madeline Stanford, guilty of murder as charged in the indictment. Or, we, the jury, unanimously find the defendant, Madeline Stanford, guilty of manslaughter as included in the indictment. Or, we, the jury, unanimously find the defendant, Madeline Stanford, not guilty. We will now have arguments of counsel. Ms. Johnson.
May it please the court?
Yes, ma'am.
Ladies and gentlemen of the jury. You're sitting here under a different oath than we talked about last Tuesday. Now you have to follow the law. If you feel sorry for her, if you think because she's a woman, any of that matters, the time to say that was last week. Now, none of that matters. Her remorse doesn't matter. The fact that she's a woman doesn't matter. The fact that she wants you to believe she was an abused woman does not matter. All you are here to do is decide if this woman committed murder, okay? Before we get started on everything, I want you to remember, what they say is not evidence. This is evidence. What happens from the stand is evidence. Their questions are not evidence. Do not consider them in your deliberations. It is not permissible. We talked last Tuesday about the 2 ways the state can prove murder. It can be an intentional and knowing act on the part of the defendant with the intent to kill, or it could be serious bodily injury that did result in his death. Well, how do you know this is murder, ladies and gentlemen? Let's go through the evidence. That 911 call the defendant made an hour later gives you most of the elements. She gives you that on October 3rd in Dallas County, Texas, she shot Tonabari Badam with a firearm, okay? She gives you all of that. She gave it all to you yesterday on the stand. You know he died. Intent can be formed in an instant. I put my hand out during jury selection, and you know, when I put my hand out, I didn't wake up intending to shake your hand, but in that moment I put my hand out, and you knew what I was trying to do. That's as simple as this is, guys. That's all you have to do. So they want to make her intent the issue here because she didn't wake up that morning with the intent to kill Tanabari Bado. I suggest to you that she probably did intend to that morning, but if you want to believe that she was cooking, taking care of her kid that morning, and didn't wake up with the intent, it doesn't matter. In those moments directly before the murder, that's how you know her intent. So let's look at everything, okay? A few days before the murder, you're going to see that she sent him a text message. I will have no pity for you. Kill you in the name of self-defense. Well, look where we are, ladies and gentlemen. Look where we are. She killed him and claims it was self-defense. The defendant told Samantha the day before at that incident at TM Classic Cars in Haltom City she would kill him. She sent him a text message and a Snapchat in the minutes right before, asking where he was. And what did he tell her? I'm at work. I'm at work. He had no plans of meeting up with this woman. In fact, he lied to her because he didn't want to see her. So any idea that he called her over there for some money is absolutely absurd. You have the phone records, and you have him telling her in 2 different mediums, I'm at work. If he wanted to give her the money, why would he tell her he was at work? So he's surprised when he sees her show up, because that's not where he told her he was. He drives by multiple times after seeing his car out there. And unfortunately, one of those times, he happened to be going to his car to get something that he forgot. She parks her car in the middle of the street with her 5-month-old daughter in the back seat, his 5-month-old daughter in the back seat, and goes towards him with a firearm. I don't know if you guys caught this yesterday, but what she said on that stand was, I walked up to him and I said, are you going to give me my money so I could go? How many times had she asked him for money? Go through the text messages, go through the Snapchats, and he wasn't giving her the money. So she had to do something else to get her money. Now she has to say, give me my money, but be a little bit more forceful with a firearm. She went to where he was. She got out of her car and went towards him with a firearm. She then tampers with the evidence of the crime scene by taking his phone, the one real piece of evidence that might have recorded this entire event. But she's already thinking. She goes back, not to check on him. She doesn't care about that because she doesn't even call 911 for an hour. She goes back to get the evidence, to take his phone. And she only calls 911 after what? After finding out from his sister and his mom that he is in fact dead and her car is on video. Look at the crime scene to determine her intent. You heard them ask for a tele. If somebody doesn't know how to use a gun and they think they have to rack it every time, would it eject a live round? Yes, it would. Well, guys, what do we have? We have 2 unfired and 2 fired cartridge casings. What do you know? 1 shot went through the window, 1 right into his head. Shoot, rack, shoot, rack. Every time she pulled the trigger, every time she racked the gun, she is showing you her intent. That is not an accident. She knew how to use the gun. She told you she took a class. For them to act like this is reckless and this is somebody who's shooting up in the air and doesn't know how to use a gun is absurd. Because she told you she wasn't shooting in the air. She wasn't shooting at the ground. She was aiming at him. The height of the window, about the height of his head. Misses the first time, if that's what you want to believe. Gets him that second time, aiming at him. When you pull the trigger of a firearm while pointing it at another person, what is going to happen? What is your intent? If you don't intend it, is it not reasonably certain that when you point a firearm and pull the trigger at somebody's head that they're going to die? This is murder. Now you just have one job. Is it murder that is committed in self-defense? Defense. Here's the law that we talked about last Tuesday, okay? A person is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to protect from the other's unlawful use or attempted use. The other's use or attempted use of force. And then we talked about when you are going to use deadly force to protect yourself. What is it? There is this additional component of proportionality. Why is that? We talked about it because if you are going to take the life of a 22-year-old man, a son, a father, a friend, a brother, and turn them into this, you better be very certain that your life is in danger and you need to protect it. So when you go back there and you're reading through that charge, you want to ask yourself, what is this woman protecting herself from? What force is he using or attempting to use? If there was any force used, was that force deadly? Was it deadly? That's what's required. And if it was it unlawful? Ladies and gentlemen, if there is no force being used, then it can't be unlawful for her to have to defend herself. You also can't start the fight. Well, who came there unannounced, unexpected, with a gun? She did. These are her actions, her intents on that day. He is at the place where he is living with Gigi. That's where he is. She approaches him. He's unarmed with a gun. So who would have the right to protect themselves in that situation, ladies and gentlemen? She said yesterday on cross-examination, when asked, do you think he was scared between the threats and her showing up with a firearm? He could have been. He could have been scared. He could have been the one who could defend his life, not her. Her life was not in danger. She doesn't need to protect herself from anything. Even if you have to go to the rest of the analysis, which I urge you that you do not need to because there's no unlawful force she's defending herself from. But even if you do, one of the panel members looked at me and kind of laughed when we were talking about self-defense, and I said, do you need anything? You got it? He said, no, it's just kind of simple. It's like a stool. It's like a three-legged stool. And if any one of those are there, it falls, it fails. This is not self-defense, it fails, but let's show you why. They are going to spend a lot of time, I expect, about her shoes and her reasonable apprehension of danger. Well, you take her circumstances, but you put yourself as an ordinary person in her shoes. Would they have responded the same way? So let's talk about what her shoes are. She's in a toxic relationship. You heard on that audio call on Snapchat. They weren't really ever in a relationship, but whatever it was toxic on both ends. These are young people. That's what this was. This isn't abuse on the part of one or the other, it's toxicity. She's not a battered woman, she's not a battered single mother like they're gonna paint her out to be. This is just a toxic relationship. She's a mother with a 5-month-old baby in the car, driving around with a loaded gun, going to the father of that baby. She's angry that he lied to her about being at work because what do you know? She's already in that neighborhood looking for him, driving around. Angelica told you she saw that car drive around at least 3 times. That's her shoes. What else do you know? What else is she mad about? She's mad about the money. That's what this is. She was going there to demand her money. That's what it is. Do not be fooled by all the rest of this. She's angry he wouldn't watch the baby the night before. This abusive man wouldn't watch this baby. She's angry. Those are her shoes. She's fucked up. She's been fucked up a while. Those are her shoes. Then you have to ask yourself, even putting myself in her shoes, is this reasonable? It's an ordinary, prudent person in her shoes. If any of you were in her shoes, would you have responded the same way? Let's talk about it. Why is it not reasonable? Do you pop up on your abuser? Insert yourself in their conversations at work? Follow your abuser and their new girlfriend? Ask them to watch your child? Get angry when they won't watch your child? Talk to your abuser the way this defendant does? Confront them at their place of work? Post their communications on social media? Do you repeatedly call and text your abuser? Do you try to make your abuser mad by telling the other women your abuser's with?
You have 5 minutes,
Thank
Counsel.
you. Do you film them? Do you sleep with other men? Do you want your abuser to be a father and then take them away from your child? Her actions are not reasonable. This doesn't make sense. When she took that stand, you guys get to treat her like any other witness. You believe some, all, or none of what she said. And you know, in that 6-minute 911 call, she lied to you 8 times. Is it immediately necessary? There is no threat against her. She gets out of her car with a firearm. She is not defending herself against anything. And this whole thing to protect her unborn child or the child she left in the car as she drove with a loaded gun, you don't even need to consider that because it is absurd. She started it. Was it proportionate? No, he didn't have a weapon. Ordinary and prudent neighbors who are watching this from down the street tell you he was holding his cell phone recording this. He is holding his cell phone recording this. Even by her own words yesterday, he's not bad all the time. This is insane. Would an ordinary and reasonable person wait an hour to call 911 and leave the father of their children dying as a result of their actions? She's not normal. She told you that. Her circumstances do not make this self-defense. He just wanted to argue and play games. Those are her words. That's not a threat. He said he would kill himself. Did Edgar call 911? Within seconds. Within seconds. That is what is reasonable. That's what is reasonable. You don't get to play victim and take somebody's life and end it like that because you want to pretend to be a battered woman. You are the sole judges of the credibility of the witnesses. They are going to harp a lot on Officer Smith's summary of what he saw in that video. Go watch it, look for yourself. His opinion doesn't really matter because he's looking at it without all of this. Angelica's statement about him holding the phone is corroborated. That's what the video would seem to indicate, that she just got out and shot him and left. Nothing corroborates her version that there was a threat. There is no threat to defend against. They're going to attack. What they did is distract you from the facts. They want to talk about all these other things. We talked about in jury selection. Your job is to look at this immediate day, October 3rd. You can look at everything else to put yourself in her shoes, but it doesn't matter, guys. On October 3rd, she committed unjustifiable murder. They kept asking Gigi, well, wouldn't that make you mad? Wouldn't that make you mad? Anger doesn't justify this. There is no justification for taking his life because you're angry. All you know about her and her shoes is that she's a hypocrite. She threatens him, holds his child over his head. You heard in that voicemail. You'll never see your kid again. She repeatedly calls him, follows him, pops up on him, pulls a gun on him. You can't protect your children from people who pose no threat. The only threat to that child that day was this woman driving around with a loaded gun. They bring up money, other women, marijuana, blackmail, hormones, pregnancy. None of that goes to self-defense, ladies and gentlemen. That is distracting you. That's insulting your intelligence and your ability to look at this evidence. All they proved was that she is the only person in the world who had motive to kill him. She wanted money. She's angry. She's jealous. She's trying to sabotage his relationships. That's her, not somebody who was a meek victim who sat up here talking and crying. That's not her. This is her. That's who she is. Dishonesty and anger don't equal self-defense. Toxic relationship doesn't give you self-defense. Wanting money doesn't give you self-defense. Feeling violated doesn't give you self-defense. And being really emotional does not give you self-defense. We cannot send a message to the Dallas County community that you can murder somebody because you're angry over money and take away the potential that that life would hold. We're never going to find out if he would have wound up being a good father. We're never going to find out what he would have made of himself in this world. His mom will not see him walk down the aisle at his wedding. She won't get to dance with him. His daughter won't get that. Because this woman is angry. And she's not crying because she thinks that this is self-defense. She's crying because she's caught. And today is her day in court. Today is the day that you deliver a message to her that in Dallas County, Texas, you cannot take somebody's life because you're angry and then claim self-defense. We're going to ask that you find her guilty of murder because she is.
Thank you, Ms. Johnson. Mr. Gucci.
May it please the court, counsel. Ladies and gentlemen of the jury, I want to thank you for your time. I want to thank you for your attention. I want to thank you for the commitment that you've made over these last 5 or 6 days. You know, one thing I will say after listening to the state's argument that we can't agree on, and you heard the prosecutor say this. He was the abuser. You don't follow your abuser. They concede he was an abuser. And we agree with that. But I will say this, and we also agree, you are the sole judges of the facts and the credibility of the witnesses. Each and every one of you are here in those chairs as judges, independent. You're here because of your background, you're here because of your knowledge, you're here because of your strength, you're here because of who you are, you're here because of your life experiences, you're here because you are a citizen of this county that's qualified to be a juror. And what does that mean? That means you are a shield. It's not a we, the government. You're a shield for this person sitting here that's accused. It's the citizens accused. That is the law. This is what the judge in this courtroom instructed you, that you are the sole judges of the facts. You are the credibility of the witnesses, and you determine whether or not someone's cherry picking the evidence here. You determine if they prove this case beyond all reasonable doubt. You hold the state to a burden of beyond all reasonable doubt. Not a bunch of argument, not a bunch of we in the community, not a bunch of, hey, this is my view of it. Of course they're going to give you their view. But let's look at the whole view. Okay? And it's not because I'm telling you. Judge Mulder has told you in these instructions, right here, this is your playbook. Okay? And when we go look at page 5, the defendant is not required to prove self-defense. It is the state's burden to prove beyond a reasonable doubt that self-defense does not apply. Okay? The burden never shifts. It stays right there with that table. And you know why it doesn't shift? And you know why you don't lower that burden? It's because of who you are. It's because of your family. It's because of your neighbor. It's because as a citizen of Dallas County, if you're sitting in that chair, you want someone like you that's going to hold them to that burden. And not drop the bar. Because if you drop the bar, you drop it for yourself, you drop it for your family, you drop it for your own child. And let's just get this elephant out of the room. For the men in this courtroom, if you saw what someone did to your daughter, think about that. Think about that. If you saw your own daughter getting punched, getting punched, getting punched, getting punched in the mouth, like this young lady who came on the court, came up on the stand, Miss Adahi, you heard her. You don't hit women. You don't hit women. Men know that. Real men know that. And real men know if you had that happen to your own daughter, it'd take whatever to hold you know what room the state is in. I just don't know. I'm having a little technical difficulty here. There it is. The judge has told you in these instructions, not what the state tells you. And they didn't talk anything about apparent danger. They sat up here about self-defense. But the law is, and what Judge Mulder has told you right here, that it's a reasonable belief that would be held by an ordinary prudent person in the same circumstances as the defendant, that there's no duty to retreat if they have a right to be there. And in considering the circumstances, on page 7, you place yourself in the defendant's position at the time and at the viewpoint from this person right here, Miss Madeline Stanford. That's the viewpoint that you take it in. The viewpoint of Madeline Stanford, and you saw in that video, was Tonneberry in the video pointing a gun and looking at her. And when she says, "Don't point that gun at me," click. He didn't give a rat's, you know what? That's who we're dealing with. From her viewpoint, we're dealing with this relationship. This is her mouth. In January of 2020, just a few months after he got her to open up a bank account and run some money through, and she found out about all the women and what kind of guy he really is, it's like, hey, I don't give a rat's ass about you. You don't want to be with me, I'm going to pop you in the mouth. The violence that she saw within the first couple of months of their relationship. Think about it. And she sat there with him because she felt sorry because he was going to kill himself, or said he was going to kill himself. You know, if you heard the evidence about their relationship, it's not me telling you to consider the relationship. It's the law. It's the judge who's instructing you from her viewpoint. You consider from her viewpoint the relationship with this man. This man who's bigger than her, this man who's more powerful than her, this man who looks at her and he pops her in the mouth because she doesn't want to be with him. That's how their relationship started. And then she calls the brother to say, hey, look, what's going on here? As he's taking pills, trying to hide her. You saw that. We brought that to you. We didn't say it. We put it up there and you saw what happened. When they continue the relationship, he's pursuing her. I don't know where they're saying that she's just chasing the abuser. This thing starts out, this guy's telling how much he loves her. Don't leave me. Those prototypical signs you heard Miss O'Connor talk about. You heard her say that. The good times, the honeymoons. Don't leave me, don't leave me. Don't leave me, I'm going to point a gun at you. I'm going to show you how much power I've got. I'm going to show you the control I have. They continue on in the relationship. And he pops up so much, she calls the police. On 3 occasions. 3 occasions she calls the police. Is that chasing your abuser? Come on. Is that chasing your abuser? You guys can see it. You know from just the evidence. you've got a physical act, and then you've got the manipulation. So from her viewpoint is what we're looking at. That life experience in their relationship. Not only did he put his hands on other women at the same time, he was putting his hands on her. And you know how an abuser acts. Did she sit up here and slam her fist like, hey, how hard to hit you? Kind of like this. You know he knocked the crap out of her. Violently and punched her. Think about your fist. Think about how strong you are. And think about what you could do to hit someone in the mouth that's weak. Her viewpoint. And you think about if that was your own daughter you saw, you know exactly what you would do to that guy. You know exactly what you would do. As we progress in this relationship, it gets worse and it gets more toxic. And we're not denying that. We're not at all. But this woman right here, and I'm not trying to say it's just a woman. We're not saying that. We're not saying it's some woman that's pregnant and that's hormonal. We're not saying that. We're saying that you have the law says you have to put yourself in her shoes, that's pregnant, that has a child, and that's been abused. That's been hit in the mouth, that's had a gun pointed at her, not only on multiple times. You heard about California. You heard Hannah Sarmake come up here. How much courage does it take for someone to get on a stand for a friend and sit up there in front of people they don't know and face family members and face lawyers and police officers and look up here and say, yeah, this is what I saw him do to her. I saw him grabbing her by the hair and popping her in the face. You think she's up there just BSing you? Do you really? After seeing a gun, after seeing two women with bloody lips, you think Hannah Sarmay is up here telling you, oh, she's just a pregnant woman with hormones? How offensive is that? To stand up here and say it's just a woman deal. When you see the kind of person in violence. As we go through this relationship, she gets pregnant, and as she's pregnant, you see all hell breaks loose between these families. You see it. They want the baby. And what reasonable mom, and if I say something, mama bear, you know mamas, you have a connection to your children that's different. You know that. You know sometimes moms don't even sleep because they're worrying about their child. That's your real life experience you can bring to this. You know mamas protect their children. Don't let his neck jerk. Hey, don't come in here drunk and wake up the kid. Is that unreasonable? Is it? It's a mama's internal protection. That's where we are. But as you go through this argument after someone has a child, and you know the father is an abuser, which the state has agreed in that little post, he's an abuser. Your protections come up, and what she was doing was reasonable. And when they decided to co-parent and that it's not gonna work, you saw how this thing started to unfold. And you saw it's a reasonable act to say, you're gonna not just come over here to my apartment, my first apartment, at 22 years old, and just come up here and lay up on me and take my keys and then get all high and be drunk. I got a baby. You need to change your lifestyle. And the request for some money, come on, fellas. I love Detective Sarah. Outside of this place, we're friends. Up here on the stand, it's business. Okay? There ain't no fake busted lip. There ain't no fake drugs. There ain't no fake gun in this guy's deal. I asked him, I said, did you consider before filing this case any of those contacts with police? Did you consider the fact that he had an arrest or charge for his own family that called him and threatened him? They were scared of him. Did you consider any of those contacts with the police where there was robberies involved? Did you consider 2 other women that he assaulted, that they claimed he assaulted? No. Didn't look at any of that. Okay? Did you consider the fact that during the offense, when Officer Smith says he was coming towards her in that video? You gotta look at this thing. You're the judges of it. You don't let them cherry pick. You don't lower the bar. And you don't let them throw up a bunch of words, suck a dick. Okay? You don't let them do that and try to embarrass her. When we get to her mind state, her state of mind, you see that it's falling apart here. I can't eat. I'm as emotional as fuck. I keep throwing up. I'm nauseous. I'm irritated. I'm sad. Like, bro. His response? His response? Oh, honey, I'll be home in a minute with some dinner. I love you. It'll be okay. You know that never happened. His response, Marie, change the appointment. I can't miss my court unless the bell phone will go off my robbery case. I mean, come on. She's over here telling this person that's the father of her child, who she's struggling with keeping. She's just had a baby. She's 21, 22 years old, in her apartment the first time. She's had her ass beat from here to Kingdom Come. She's had a gun pointed at her. She's had her hair freaking pulled out. She's been stripped out of a damn car and thrown on the ground in front of her best friend. He's been calling her a cum bucket. You're fat. I'm going to take that baby from you. All this crap you've heard in this courtroom. And she says, hey, just come home and eat with the family. And you know what he says? Oh, come on now. I got my robbery case. I can't take that. I got my robbery case. I got to go defend myself from robbing somebody. That's the guy that we're dealing with. I'm sorry for the family. I'm sorry for how this is happening. I'm sorry for that young man's life. She's sorry for it. But you've got to get in her shoes. You're the judges. And you don't lower that bar. Because you know what she says? He says, that's too risky. That's too risky. I can't take you to go terminate this baby. That's too risky. Oh my God. I'm just killing myself at this point. This is 9/30/21. 3 days before, her state of mind is, oh my God, I'm going to take my own life. So when the prosecutor gets up here and he shows you all this crap about, I'm gonna shoot you, I'm gonna do something dumb, don't you think do something dumb is take her own life? Don't you think that's what she's talking about? And let's just talk about something, I'm not gonna get too scatterbrained here, but I'll tell you this. When he comes over that time on 9/25, and 9/25, we're getting to the offense date. 9/25, when he comes over and rolls up on her and wants to hang out, and wants to be high, and wants to go sleep with her, wants to take over her apartment, she says, get out. They fight over some dang washing a shirt, stupid stuff. Get out. The baby's up there trying to sleep. What does he do? Do y'all recall? She's got a 4-month-old in her bedroom. She's got a child, an embryo, a life in her stomach, whatever your viewpoint is. And what does he do? He grabs her by the neck because she's trying to get him out and still hits a pregnant woman. Still hits a pregnant woman. Is that where we are in society? She's crazy. She's just crazy, man. That's where we are. Some crazy woman with a 5-month-old that's just going to wake up one day after taking a bath with their baby, after sitting there sending videos about cooking, and gonna just roll up, boom, she's crazy. Over what? $500. That's not what happened. That's not what happened. So let's get to what, when you're looking at these kind of cases, this is how you look at them and evaluate them. I'll touch on 10.2 or state of mind. And this is real important. This is real important. You saw all these forensics and all the scientific stuff. What did that scientist, that the FBI guy say? They talked for an hour, conversations, October 2nd. There's a 40-minute phone call. There's a 20-minute phone call. There's texts, there's snaps. He didn't know what they were talking about. He didn't know. He can't tell you. All he can tell you is locations and where they were. The only people that can tell you what they were talking about is my client and Mr. Turnerberry. And you know from reading this case and hearing the facts, this is a 3-4 day deal about getting her money back that he gave her to go have and terminate a baby. I read you the chats. Mr. Barney read you the chats. It's all about, here's my money. He slipped his money over there to her. He takes it back. It upsets her. And this is a goose chase to get my $500 to have my money. This isn't a case about I want your money. This isn't a case about the lifestyle, I'm taking advantage of it. This is a woman who knows she's had her ass beat. She knows she's had a gun pulled at her. She knows she's got a baby she can't handle now. And she knows she's got a life inside of her that she just don't know if she can take. And I submit to you, we've all been in a position where we just know in life if we can just do it. But she's going to try to walk through it. So when she gets to 10-2, and you know they've had conversations on the phone, you know she goes to Hotham City, you know she goes down there, and you heard two versions. State's version, defense version. You heard from a witness that got up there and said, she stabbed him with a pencil. She raised all kinds of hell. I showed you the picture. There's a video camera sitting right there. We don't have any video of her version. And we didn't hear anybody say see any evidence of any kind of stabbing. What she told you was true. She went down there to go eat, go get her money. Well, she said she went down there just to get her money. She went down there to get some free food. They have a confrontation over, it starts out jerking the baby. The argument ensues, you hear them on 911, They're all two young kids screaming. But what you don't hear, what you don't see, and what the FBI agent says, and he mapped them all the way to 601, that they're following each other. What he didn't map was after 601. And when the records show that they continued to talk and communicate, and she thought she was going on this other goose chase just to get her money for this termination and go. And they end up at T. Reed's apartment. And Terrell Reed comes down while they're in the parking lot, and he gives Turnerberry a gun, and Turnerberry takes that gun, and he racks it, and he looks at her and says, "We ain't friends no more. We ain't friends no more." And that's the last conversation in person she had with Turnerberry. As she goes home and she wakes up, there's no evidence that she woke up masterminded to go kill somebody. She had no intent to do anything like that. She woke up like a mother with her child, and she testified, taking videos of herself with the child, sending cooking instructions out on the internet, or talking about cooking things for her dad's birthday. And she woke up like a normal day. She just made a stupid mistake to go over there and try to get her money again based on their conversations. Come on over here to Stevers and get your money. She told you she'd been at that location. She's telling you what she was doing, and she goes over there. And as she gets over there, and she has communication back and forth, Mr. Varney showed you some of the communication. You've seen some of the chats. You've seen some of the phone calls. It's about getting her money. And as she goes over there, in this video, you see just a snippet. They don't bring the video of her car driving back and forth. They don't bring other ring cameras. It's a snippet of a video that they bring where she gets out. She walks over to Mr. Turnberry. She has a conversation. "Give me my money." He just gives her that 1,000-yard stare. He looks at her and puts his hand right there in his pocket. And as he's pulling something out, she fires a shot. You know she fired a shot. The first shot goes straight through the window. A wild shot. As her gun is out and he's moving towards her, that's where the rubber meets the road, because you know good and well the fear in her life of him taking that gun from her and him using that gun on her or her children or himself, it's become a deadly situation. And she fires in his direction, and you see from the crime scene what happens next. But it's important for y'all to understand, when you look at a crime scene, it'll tell you a lot. When you look at a scene, you see how the casings are together. You see the short, small proximity of where these two individuals were. You know they were in close proximity. You see how the two casings will eject and be close to where the scene is. And you see two live rounds, and you see her running backwards. Those things you see. What you don't see on the video is you cannot see what kind of trees there are. You can't see anybody's hands. You can't see anybody's conversation. You can't see what's going on that video. All you can see is, just like Smith said, looks like she comes out and runs towards him, and you see her running backwards, firing. Smith's the one that looked at that. And what the prosecutor talked about early on in these instructions is what you've got to look at here. Self-defense, apparent danger. The self-defense, apparent danger on page 8 is what we all have the benefit from. These are Judge Mulder's instructions. It's from her viewpoint at the time that was there an apparent danger that her life or serious bodily injury was imminent, and she acted from her standpoint. And it doesn't matter if it happened or not. It doesn't have to happen. And that's what Judge Mulder says in here, whether it happens or not, whether he did it or not, whether it was real or not, it was whether or not she believed at that time that it was about to happen.
Objection, Your Honor, there has to be a reasonable belief.
The law, the jury, will have the charge, and can read it them for themselves.
I'm not gonna, argue that little objection. Reasonable belief from her standpoint. Okay? I know you guys are tired. I know you've been here hearing a lot. But I need to go over this with you and make sure that we get this out. The evidence in this case with Miss Obregon, nice lady. She told 3 stories. Every time she talked to the prosecutor, it grew. And then we heard something new when she got here. We also heard her brother had a case. We didn't hear from her brother. They mentioned him just then. With all this power, all these subpoenas, all this, we're going to bring the guy down here. You saw the viewpoint of where he was looking from. That's him drinking a beer. And you see their other house right here. You see their viewpoint. I like Miss I thought she's a nice lady. But you can't rely on what she saw and said. She told 3 different stories. Middle Reel didn't show up. You didn't see anything like that. You didn't see all the video cameras here from Seavers. It was never pulled. All the officers with their body cam, you didn't see that. You didn't hear that. You heard from Smith, who was the first on the scene. I like the guy. I think he's a good, I think kind of a straight shooter. Question is, why did he cut his body cam off? His is only 40 minutes. Johnson's is 148 minutes. And then when he comes in court, 4 years later, kind of downplays that he didn't say, I saw him running towards her. If that's what my report says, then that's what it says. Did I look at it? No. Sarah, same thing. He wasn't there. He had everybody write reports. About Smith's comment, when he did the video, did you see him run towards her and then fall? What's the significance of that? Because now he is aggressive towards her. Whether or not she came and pulled that gun and said she felt the threat, it was real on now. I think we've covered that, you know, my client testified credibly. I submit she testified very credibly. I felt like she was honest with you.
You have 10 minutes.
Thank you, Your Honor. She answered those questions, those tough questions, and she got up here and told you how she felt and how she was abused and what was in her mind. You know, I feel like on the state, when you look at this case, they have not disproved apparent danger beyond a reasonable doubt. They have not disproved apparent danger beyond a reasonable doubt. And it's a law that you have to disprove self-defense, apparent danger beyond a reasonable doubt. And I know they're gonna come up here and they're gonna talk about my client's actions in 911. And submit to you that she reported because she was called. She was called. When Rolla called her, she was. And she was afraid of what she did. She was in fear of what she did. And she was scared of what she did. And she panicked. She had just shot the father of her child, realized he didn't even have a gun, goes over there and picks up what she thought, and it was a phone. And the fear, the stress, all that of knowing what you just did, she panicked. And when she panicked, she tried to downplay it. She was honest about that. She called her mom at 22 years old. Think about that phone call. Probably half the parents in this house would say, "Get your butt home, don't say a word." The other half would say, "Call the police." I don't know what you do as a parent, but I know what she did. Madeline's mother said, "Call the police." Call the police.
But Judge, Your Honor, argument facts outside the record.
Madeline's mother told her, I'm sorry, Judge, go ahead.
Overrule, the jury will call the evidence as they heard it.
We're wrapping it up. Just stay with me right here, okay? Just stay with me, ma'am. She calls the police, and you heard her voice. I didn't mean that to happen. I didn't mean for that to happen. I didn't mean for that to happen. I didn't mean for that to happen. And she did. And she was honest, she was scared, she was afraid, and she told you she didn't mean for that to happen because she had no intent to go over there. She's not this monster like they play. They come over there and do that. She was just coming to get her money, and based on all the experiences she's had in front of Barry, and based on the gunplay that he's given in front of her, based on the way he was pulling it out of his pocket, based on those factors of his, how he reacts, in that moment, she believed that he was about to pull a gun. And that's this case. I submit the state is gonna come here, they're gonna talk about a few chats and phone calls, but I want you to recall this. Sarah got up there and Smith got up there. They're both officers that put their life on the line every day. They put their gun in their holster and they go out there and protect this community. And they told you from the witness stand about the apparent danger that they see when they come up upon someone. And the furtive gestures of 1,000 stare, and what will kill you is the hands. They know the hands will kill you. They know that if someone is just staring at them, that's apparent danger, because they've been taught this. And they also told you that if they know a known suspect to be violent, that they're gonna be at a heightened risk. And so even in officers, when they are faced with shooting an unarmed suspect, they have been taught to look at these things. And what's the critical factor is the relationship. If you know that that person's capable of violence, you know that person's got knows how to handle a weapon, and you know that person has committed violence on you, and you know that person's put a gun on you, and you know what happens when you walk up there, that they're unpredictable, you have a reasonable fear and apprehension when he reaches in his belt to pull something that's not responsive to, hey, just give me my money. That fear at that moment, that's why she acted. And these officers told you that their life, his life, every day can be gone in a split second. A split second, your life is gone. And that's where we are. A snippet of a video, a 28-second deal, and a split second, her reaction in her mind, based on her ass getting whipped all the time in the gunplay, she reacted. That's where we are. And you know what? You got their case and you got our case. And you got a question about what happened here, you got a question about what happened there. And if you have a question that's reasonable about how this thing went down, you know what your rule is? Not guilty. Because the judge tells you if you have a reasonable doubt as to the elements of this offense, if you have a question about who you think's right, what you think happened, you resolve that doubt in favor of Miss Stanford. Because you're Miss Stanford, and you're Miss Stanford, and you're Miss Stanford. You're the shield of who's sitting over there. You're not buddy up with the state. If you start doing that, chaos is going to break out. Our forefathers knew that 200 years ago. They knew that this system, you have to have judges that are fair and impartial, that have no stake in this deal. You've given up 6 days of your own life to sit down here and listen to these facts. There ain't no question this guy was violent. There's not a question in your mind. There's no question in your mind what you would do if they hit your own daughter. He wouldn't even be standing if he hit your own daughter. Not once, not twice, not 3 times. Think about hitting a pregnant woman. Her mindset was reasonable for her and her shoes. This 22-year-old woman, not just because she's a woman. I'm tired of hearing that. Not just because she's a woman. It's because she's a pregnant woman that's had her ass beat by this guy and manipulated by this guy, and she's fearful. And I know you saw that. So as I close, when Mr. Varney gets up here and he puts on his map, his road map, ask those tough questions. I'm just a lawyer. I'm a country guy. I'm not just saying that. You can hear it in my voice. I don't have all the answers. I may not have asked the question you would have asked. You've got to ask those tough questions. You've got to get up here and go, Mr. Varney, why didn't you tell us about him pointing a gun on her when she was young? Why didn't you put the bruise out when you were putting on your case? Why didn't you call Aniola, his first girlfriend at the time, and he punched her in the face? Why didn't you tell us about Detective Sarah when he didn't consider those robbery cases when he had a gun? Why didn't you tell us that he was on robbery? And then why didn't you tell us about the violent nature of this guy? And why are you talking about some chats that you don't even know what they're talking about? Why are you going to focus on their chats and their little cell phone play when you don't even know what they're saying on that hour conversation? You're just assuming. And when you start assuming facts, when you start listening to speculation, you're going to get it wrong every time. Nobody's bad in this courtroom. We all know each other. This is just business. This is your business now. You don't lower that bar. So when you get here and you get back and you deliberate, your playbook from Judge Mulder who I know I've upset here, not once but twice. When you go back there to your jury verdict form and you're unanimous, because you have a doubt as to this grainy video and what happened, and they didn't tell you how violent the guy was, and you have some questions about, well, that may sound reasonable, but that sounds reasonable too. When you have those tough questions, you check not guilty. Because it's the job that you do. You have no feelings, you have questions. You don't throw your life experiences out the door, you use your own life experiences. The judge has also instructed you that if you do have an issue as to whether or not it is guilty of murder or manslaughter, you resolve that doubt in the lesser included. You understand that? You resolve that doubt with the lesser included. Ladies and gentlemen, I truly thank you for your time. I thank you for your efforts. I thank you for all this attention. Judge Mulder was right. We've never been in a situation where we've jumped around 3 or 4 courtrooms and had, power outages. And these cases are tough. There's a lot of questions. But I know, after looking at this evidence, there's no question that she was an abused woman, an abused pregnant woman, who at the time that she dealt with him, not just that night, and we all know this, when you deal with someone that's unpredictable, think about it. When you deal with someone that's unpredictable and that's been put violence on you, that's done something crazy, you're always on edge, aren't you? You know those kind of people. You're always on edge because you don't know what they're going to do. Thank you for your time. I submit to you that my client is not guilty. I'm asking you to find her not guilty, not because you like her or feel sorry for her, she's a woman, because they have not proven their case, and my client acted out of reasonable fear that something was about to happen, that it was dangerous to affect her life and the lives that she had with her. Thank you.
Thank you, Mr. Bussier. Mr. Bernie, you have 27 minutes.
Police court. Defense says, this is just business. But it's not just business to me when we're talking about somebody's life. We're not just talking about shooting the breeze or people being friends outside the courtroom or whatever. The decision she made took him from a live person to laying on a slab in the medical examiner's office. Whatever Tonneberry was going to be, whatever he could mature into, whatever he could grow and learn from, that ended October 3rd, 2021. And the other part that ended that day was any chance his side of any story could ever be told again. Right? Because you heard 5 or 6 hours of the defendant saying, well, this is what happened, and this is what he said, and this is what happened next. And the defense said, why didn't we argue with her about that? Why didn't we call someone else? Well, if it's 2 people involved, they said it. There's 2 people involved in a relationship. She's had 3 years to get her story together. She has had 3 years to tailor her story around the facts of that day. His story ended that day. We could never call him as a witness and say, well, did it actually happen the way she said it happened? Did you just beat her up just because you just felt like doing it every 2 weeks? You don't, just because she says something on the witness stand, you got to decide if you believe it. And when you say you judge someone's credibility, you have to think, what reason does this person have to lie or make something up? And that's in any witness. Any witness, you can say, what reason does this person have to lie? Well, she already told you in her chat she sent to her friend, what do I have to lose? Why not just say whatever when I get on this witness stand?
Objection. That's a misstatement of the facts.
Overall, the jury will remember the testimony as they heard it.
So, evaluate that. If you're back there and you're deliberating and someone is saying, well, she said this is how it happened, ask yourself, is there evidence that it happened that way? There are some pictures that they've shown you, and there's 2-second videos here or there. Even the video, go back and watch that video that they submitted of him supposedly pulling a gun on her. Take it off of that thumb drive, put it into the computer and watch it. Listen to her laughing, saying, look at this bullshit. And then him laughing. They're sitting in a car next to each other. She's filming into his lap while they're laughing about it. But now, because everything's on the line, she's on trial, that turned into, oh, this was some harrowing experience where he's pointing a gun at me and I didn't know what was going to happen. Think about it. His story will never be told. And all the evidence that she took off the ground that day, picked up, drove down the street, and threw out of a window. The defense just got up here for about 40 minutes or so and talked to you. Did they explain how or why that was important? Any piece of evidence that he would have had that day, the video of him watching her just like he had on September 28th. They said it was the 25th, it was the 28th. September 28th, he recorded her with a gun, just like it was happening in front of Angelica Obregon on October 3rd, 2021. So on that day, he's doing the same thing he did 6 days earlier, but she wasn't going to let that result in the same way. So, just like we said before, if you're judging someone's credibility, what reason do they have to lie? You met Ms. Obregon when she was on the witness stand. She'd been there for 17 years, and nothing like this has ever happened before or since in that neighborhood. And the defense says, well, why is her story changing? She's had 3 years to think about this, to have more things come into her mind to remember the small details. But she has no reason to lie. They say, well, where's her brother? Ms. Johnson talked to you on that very first day of jury selection. The defense has the same subpoena power as the state. If they want him up here, they can put him up here in this chair. When they put on a case, when they choose to call witnesses and bring evidence, you scrutinize their case just like you scrutinize ours. So if someone is saying, well, why didn't the state bring X, Y, or Z? They have the same opportunity to bring whatever they think will help them prove what case they choose to put on. You heard from Edgar in his 911 call exactly what he saw. Well, it looked like he was standing there filming, and then she went and shot him. Now, we know that if you want to take anything she said as true about that day, take her story. T stood there and said nothing to her. The defense keeps saying it's a snippet of a clip of a video. Well, the whole incident only takes 28 seconds. So what other snippets do you need? She gets out. She walks towards him with a gun. The defense keeps telling you, well, that could be you, that could be you. If someone comes to you with a gun, you have a right to defend yourself. If a bullet goes whizzing past your head and the person still has a gun out, you could run at them if you want to and go get that gun from them so they don't shoot you. The one thing we can agree on is that there is no way to prove in what order these shots went in. You can't prove, no one can prove that the first bullet went through the window and then the second one went through his head. So you have to just take their word for it that that's the way that it happened. But you have States Exhibit 57. That's the video. Just watch it. We put it in real time to be fair to the defendant. We magnified the part so that you can look and see what people are doing in there. And they're so hung up on Officer Smith, who watched the video and in the first 20 minutes is standing there on the scene in the police officer version of standing around a water cooler saying, oh, well, he might have been running at her. That was 3 years ago. All the evidence that has been brought, the testimony that you've seen, he's not privy to any of that. He's not privy to the things that we're going to see up here where it started off with threats. You throw money on strippers. This is the 28th. Tanabari in blue says, you pulled a gun on me. I will show the police after following this. She says, I'll do it again. He says, bye. You put your hands on me and you hit me in the head. That don't change the fact you owe us money, period. I don't owe you shit. I should have shot you for hitting me in the head because I have a knot and a headache. You do, in terms of owing money. Run me my shit so I can dead you. Because I will go to jail behind our disrespect at this point. The defense says, as though this is somewhat frivolous. Oh, they're just sending you text messages and chats. This is what they say to each other when no one else is looking. They didn't know that you were going to be looking at this 3 years later. What's said in the dark comes to light. And so here, she says you deserve the bullet. He's talking about money. You're not going to do what you did to Douglas to me. You know, the defense keeps saying, well, you know, he's messing around with other women, and that's what is so disrespectful and offensive. Remember, they have to have a paternity test to see whose baby this was in the first place. And if you really believe that she just saw Douglas one time, and that put that fear in her mind that it was someone else's baby, I don't know what I can convince you of. Clearly, she had relationships with other people. You want to hear, I just want to hear the reason why you broke my mirror and pulled out a gun. You saw the video of her with a gun. So when they put up this picture of him holding a gun in a menacing way, this was 5 days away from the offense. I want to hear why you broke my mirror and pulled out a gun. Well, you hung up, so. He wants custody of his daughter. I don't care if I touch the car, period. Beat me in my head and I should have shot you. I stand on that. I will have no pity for you, will kill you in the name of self-defense. Bitch, stay firm. If you dead is dead is, and do what you gotta do. This is all her writing this to him. I never did. I never touched you. Well, that's one part of this toxicity in terms of this relationship. Another is, she wants him to spend time with her. The defense says, well, this is one-sided. He keeps pushing her away with violence and drawing her back in either with money or threats of suicide. Now, we already know she said she was going to kill herself. So, again, both directions. The Snapchats, I will fuck you up tonight. That's her directly threatening him. You're on Do Not Disturb because you will keep blowing me up. You're not normal. I know if you don't watch her tonight, I'm going to fuck you up. Remember you heard that message that where she wanted him to babysit? So if he is so dangerous that you can't even walk up to him and talk to him in broad daylight, why do you want him watching a 5-month-old baby? If that's actually true. Go to hell, I'm going to definitely hit you in your mouth and bust the other tooth, ho. Answer my call, bitch, before I find you and I'll fuck you up. Again, this is not the same person you see on the witness stand 3 years later. T's trial began the minute he hit the ground that day. And there's this back and forth about, well, is it because she's a woman? Yes. You heard your other possible prospective jurors. You heard that when some people said, well, if there's a woman involved, it must be because a man was beating her up, right? And a woman wouldn't be here unless a man did something to her that forced her to be here. So we know we have to deal with that reality. That he was on trial the minute he was shot in the head. Because she can get up on that witness stand and say all these things about him that he can never controvert. He can never come here and say, that's not true. If there's two people in a relationship, two people in a room, one is dead and the other one's on trial for murder, only one story is going to get told. I will end your life. I will call you 2,000 times. You put your dick in a crazy female. She said, oh, well, that was one of those times I was talking crazy. The defense keeps saying, we're cherry picking. We're cherry picking. We could sit here for another week or so and go through every message here, but you have it. If you can find where he's threatening her in here, please turn to it and consider it. I submit to you, you will not find it in here. We take the relevant evidence and we put it before you because their whole lives are not on trial. It's about what happened on October 3rd of 2021. Tia's not on trial for his whole life, just like she isn't. But what decision did she make on that one day that we can evaluate and look at the evidence and say, that's not right? The defense says, well, it would be chaos if you don't stand as a shield against the law from Ms. Stanford. I'll tell you, it would be true chaos if what they want to be true is true. That anytime someone just feels afraid for any reason, bullets can just go flying. Why? I don't want any pockets on my clothes then if I can't reach into my own pocket because someone might shoot me. You heard what she said he did. She was our best witness. He didn't have a gun. He didn't say anything. She told the truth that she lied and said he never came towards her car. That he didn't start running towards her, if you believe her. If you see that in the video, he didn't start running until a bullet whizzed past his head. She is our best witness. Only reason you won't answer me is because you're with a bitch. So she was upset that he was with somebody else. Here we see 5 missed calls on the day of October 2nd. So when we saw those messages about answer my phone, why am I on do not disturb, why won't you talk to me? This is where the frustration is starting to grow. It's not cool. I asked you for help tonight to watch her for me so I can have small mommy time, and you just refused. This is that audio recording that we played for you a couple times. Go back there and listen to it. She was mad because he wouldn't babysit. How does that square with, I'm so afraid of him that if I walk up to him in broad daylight, I have to be ready to pull my gun like I'm Billy the Kid or something? Those two things do not go together. They do not add up. October 2nd, 23 missed unanswered calls from her to him. Does that seem like someone who wants to be where she is? Someone that wants to be in the same place at the same time, either to hang out, to exchange money, or whatever. This is all in the hours before she shows up at TM Classic Audio in Alton City. I don't know anymore, just know you did this. Ain't no rebounding from any of this shit. You don't care now, but you will later. He will be dead about 25 hours away from this. 24 missed calls on the 2nd between the hours of 10:55 and 1:52. We're moving to the 3rd. 3 missed calls. Right there, look at those times, 4:53. That's when we know she's circling the block on Severs. If any of you are back there saying, well, maybe he did call her and tell her, hey, come by Severs Avenue. Where is the evidence that that actually happened? Go back to the last 2 to 3 pages on each one of those big binders and you see the actual messages they sent where he said, I'm somewhere else. She popped up on him. He didn't want to be where she was. Are you at your mother's? No, I'm working. She likes it. So she can never say, oh, I never actually got that message that he wasn't at work. She actually responded to that. So you say you're working, but never work for real, always lies. You know you weren't going to ever pay us back, but it's okay. So how can she say on the witness stand now that I was going there for money when she's already responded and said, I know you're not going to pay me. I know I'm not getting money for you. We don't have to prove that she woke up wanting to shoot someone. That is not a consideration at all. If someone says, well, I don't know if she really wanted this to happen, that's a totally different issue from intention. Intention is the intent to act. Did she want to go confront him with a gun? Did she pull out a gun and shoot at him? Yes. And we know it wasn't an accident. She testified the gun didn't just go off. I wasn't aiming to bounce it off of something. She shot at him because she says he ran at her after a bullet whizzed past his head. And then, somehow, after she shot him, picked up his phone, driven down the road, chucked it somewhere, again, 3 years ago. No one could ever know where that phone was because when she called 911, she didn't tell them, hey, you should go look on this road or next to this highway for a phone. I threw it out. Wouldn't that have helped the investigation? Wouldn't that help prove what happened if they found the phone? Maybe they see a video where T is threatening her. Maybe they see a video where they're talking it out and he starts making sudden movements. But she decided what piece of evidence, what key piece of evidence you would never have. She texts him again after she knows he's laying there bleeding out on the ground. I'm keeping my baby. Why does she do it? It's to start getting that story going. It's to start getting that story going. This is before she gets that call from the sister, from Rolla, to let her know. She thinks she might have gotten away with it still at this point. Now she gets a call. She makes a call. 5:16. She Snapchats T. Why'd your mom text me? 5:22. This is before Rolla's call. She still thinks she's getting away with it. Why did she text me? Acting like she wouldn't know why his mom would be upset, having heard that her son has been shot somewhere in Dallas. She sends this message with a question mark on it. You have it. It's right in there. Now that call, 5:35 p.m. Now she knows she's not going to get away with it. We know it was you. She goes into her phone after she's talked to two people, talked to her mom and grandmother. She goes into her phone and changes the note to herself on her phone, the one that was created the day before. It's right there in the binder there. You can look at it. But she modified that note to say, meet me at Severs Avenue for the abortion money I owe you. Why would she write that note to herself and put it in her own phone? 2 minutes before she called 911. Her story was starting that day. The 3 years she had to wrap her story around the facts began right there in that moment. Now she calls 911. And I marked it out for you. You'll have that pad back there. We listened to 6 minutes of a call. She lied 8 times in it. He was coming towards my car. We were on Snapchat. He was being disrespectful. Well, now she says he didn't say anything. She's arrested. When she turns herself in, she bonds out of jail. She testified that her mom told her, hey, get off that phone. Don't be talking about this to anybody. But she decides to. She sends Gigi Secret that audio that I played a couple times for you. Listen to it again. Hey, I know I'm going to get blamed for this. Of course she should be blamed for it. She shot him. I did it. It wasn't premeditated. I didn't mean for this to happen. None of that's a defense to murder. Those issues don't have anything to do with guilt or innocence. She can argue that in another phase of trial. But for her guilt, she just flat out said, I did it. It wasn't premeditated. Well, you're not required to prove, we're not required to prove that it was premeditated. If she just got upset while she was circling that block and she was so mad that, you know what, when I see him, I'm going to do all the things I said in the threats, that's enough. The one thing you have to wonder when you're deliberating is, what if Gigi was walking out there with him too? Would she be alive, or would there be 2 dead people out there? Would she have the same argument that, oh, well, you know, because there's 2 people there, they were going to jump me. They were going to jump on me when I got out of the car with a gun. She decided what she was going to
Object to
do.
argue facts, not evidence.
Overrule, the jury will recall the evidence as they heard it.
We might be cut off here, but the defendant goes to the GoFundMe site for his funeral once she gets out of jail. She's arrested for the murder after that. So she's in the audio that we gave you, you saw that she was worried about what was being said on social media about this. She was mad that she was going to get blamed for it. Does that sound like someone who knew what they were doing was truly self-defense? The defense says, how come we didn't call Eniola? Well, we don't know what she's going to get up here and say before she says it. If they have the same subpoena power, you heard from Eniola herself. Hey, I hit him first. I didn't think he was right for hitting me back, but I hit him first. But then we asked her, what opinion do you have of this defendant? She says, yeah, she's violent, physically and verbally. She says, I have an opinion of her that she has a violent character, and this is one of their witnesses that said that about her. We're not going to litigate their whole relationship, and I hope that that's not what you're doing when you're back there. You guys have been here for a long time. But really, the reason you're here for that long time is about what happened on October 3rd, 2021. What pieces of evidence did she take away from you on that day? Any story T could tell? Anything in his phone? Anything that could be developed from it in the last 3 years? Her actions speak louder than any words that she could say. Oh, you know what? Let me give you a couple words that she said. Only in response to something the defense said. The defense says, oh, well, he's pursuing her. He's making her come back with money. Is that back up, Jimmy?
Turn it back on, see if that helps.
There we go. That should be. You know what, I'll just go ahead and turn it, oh, there we go, oh, okay. Now we're not on duplicate. You gonna take that off, Jimmy. We'll go to page 200. I can't watch Eliana today while you at school tomorrow. This is T talking to her. Why, T? Because I have stuff to handle. I want to cook you food, suck your dick, and talk for the last time. Marie, not today. September 21st, 2021. I'm not giving you this stuff to be salacious. And the defense says we're trying to embarrass her. But the facts are the facts. She wants him at times just as much as he wants her at times. So when you go back in that relationship and you talk about whether there's push and pull or there's toxicity, there is no dispute. These are two young people in a very toxic relationship. So look in here. Please look. This is not cherry picked. This is not us saying, oh, there's only 4 or 5 messages that matter. We try to be mindful of the time. But look in here. Find something in here that tells you he's threatening her. That he's saying he's going to kill her all the time. That's the only way his story is ever going to be told because of the decision she made. We're not asking you to make some decision about all women, whether they're abused or not. We're not trying to make a decision on whether or not she's a battered woman, because we don't believe there's evidence that can be put up that she is a battered woman just by him. We have evidence of a toxic relationship in both directions. We're asking that you find her guilty of murder, one, because it was intentional. She committed those acts clearly dangerous to human life and took his life, but she intended to shoot T, and she did shoot T and take his life. This is not just business. This is not just some elementary or educational exercise. This is about a human being whose life was snuffed out at 22 because of $500, because of disrespect in her mind, because she was fed up. When you start talking about self-defense, apparent danger, or anything having to do with that, remember, it's not just you in her shoes. It's a reasonable person in her shoes. Why was that audio I played so important when she was on the stand? Because she told you her mindset about a day and a half before all this. I've been fucked up for a long time. She told me, I'm a crazy female. I'm not normal.
You have 2 minutes now.
Thank you, Your Honor. So when someone tells you who they are, believed them. She was not a reasonable person standing out there. And then also, when we say there, what kind of case? This would be a totally different case. We'd be in a totally different situation if this happened in some dark alley somewhere. If it happened at her residence, if he had gone there and he had done something to her and he was walking towards her or giving a 1,000-yard stare at her place, but she went to where he was. She sought him out that day. She wanted that confrontation. She got what she wanted. She got a confrontation. Then she thought she got away with it, right? I'm going to shoot him. No one's going to see me. I'm going to take the evidence. I'm going to hide it. But once she was caught, she started working on her story. So remember, when you hear her story, when you think about the things she said, she has had 3 years to get that story together. We ask that you find her guilty of murder. Don't meet halfway in the middle of manslaughter. Don't find her not guilty because we know she's not guilty. Go back there, look at what you need to, but if that verdict is swift and it says you are guilty of murder, no one's going to be surprised. We ask that you find her guilty of murder because she is guilty.
Thank you, Mr. Ryan. All right, ladies and gentlemen of the jury, before I excuse you to the jury room to select your presiding juror and begin your deliberation, we will send the evidence back to the jury room with the exception of the firearm. We do not send that back to the jury room, but if you'd like to see it, we can have the bailiff bring it and stand there while you look at it. If that is something you want to see, we just need a note letting us know that you want to see the firearm. All right. You will now be excused to the jury room to begin your deliberations.
All right.
Please leave your notes in your chair. You cannot take those with you. And those will be collected and I'll be keeping them. All right, let's take a 5-minute break and then I need the attorneys, please. 5 minutes.
Okay, we're going to get that computer done.
Yeah. Okay.
All right. Good job, folks. You as well.
16.
Oh, the charge?
I was like, whoa.
Take a deep
I
breath.
know.
Drink of water.
Drink water.
Did you have like an eyelash fall out or something?
My contact.
Oh, okay, yeah. I can tell there was something in your
Yeah,
eye.
I was looking down so much and squinting and my contact was.
Yeah, what's your, just go with that.
Mhm. Oh. If you want to get a certification of right of appeal, just. Just in the next 30 to 45. Thank you. I'll be right back. I'll be right back.
The penal code is not the way.
I was on the phone with him right after.
You all right?
Do I need to pick it up? Okay.
You here for Smith?
Yes, sir. If I can have my clue.
Let me see if you see me.
Hopefully.
And you showed up at the
Yep, I saw them.
trade.
I saw everybody getting up. I was like,
Not a chance, right?
Well, I will say this, what I heard about their expertise is the cheaper option. He hasn't tested out very much, and he just kind of starting to do that because that reason. That's why they don't charge as much. I would say if you were fancy, you have 30 malpractice